All right. It is now 4 minutes past the hour. Hopefully, most of the people who are going to join us this evening have arrived. Wish to welcome you to the What Lies in Your Debt weekly Tuesday night conference call. We have with us this evening who will be presenting for What Lies in Your Debt, Larry, Jesse, and I would imagine occasionally John. Larry has been dealing in the FDCPA for the last 5 years, or closely there too. Jesse's been working in the area of foreclosures for the last 7 years, and John's just one of those landmarks that's been around forever. He's been into all kinds of things over the last 10 years that I'm aware of. So this evening, why don't we start off with Larry?
No, we decided we were going to start off with John this week.
Yeah, I'll take over, guys. That's all right. I'll do some little... Sorry.
Oh, okay.
Appreciate that. Okay.
Thank you for letting me know that.
No problem. Keep it a secret till last. Well, thanks everybody for being on the call. I think it's it's quite interesting. Last week we had a pretty good call, and there's lots of good information on this. Larry had some really good information about actually getting money from your creditors and debt collectors. And Jesse's real good about the foreclosures. Both of them together, though, have done a lot of good work on the aspect of collecting money from your creditor. And I'm just starting to learn that aspect of it. And I'll tell you, the way to start it really is to just go and read all the information, just get into it, and just pick a fight. And I just tell people, take your last collection letter and go for it. Just pick a collection letter, bring one into court, and see what you get. Follow that process, because that's the only way you're going to learn this stuff, is if you do it. You can't sit back and go, wow, you got all that money? Wow, they said this. You got to do it. You got to risk, losing. You got to risk the difficulty. You got to risk a little bit of filing fees. You got to risk a little bit of your time, and it's really worth it. It's time for us to come back and to go after these guys, instead of just complaining about them running away with the court system and everything. I think we have a really good opportunity here. So, with that, I don't want to talk too much, but my area is fairly limited. I mean, I don't consider it so exciting as, how I can get a bunch of money from the banks. I have, for years, shown people how to prevent the banks from collecting money through creative means with, certain time limit procedures. It doesn't take a long time to set those things up, but, we could talk about that too. But I guess you just pass it on to one of you guys, Jesse or Larry, or whoever wants to ask questions.
Okay.
What? Can I just say, I think you hit on a key point there, John, which is to pick a fight. And the reality is the other side is going to fight you if you let them. And they're going to win unless you know how to fight back. So the key is to, understand the rules of the game. Our website is just chock full of information. And once you do that, like John said, the opportunities are there to really not only beat the other side, prevent them from taking your money, but you want to take their money instead.
Yeah, but when you're taking theirs, Larry, you got to make sure they don't get it back.
Yeah.
That's the goal of John's, system. Yeah, John will make you bulletproof, so you're broke at all times, and I don't care if you got $1 million laying around. That's kind of the beauty of his system, is that in fact, and of course, what both of these guys are failing to mention, as usual, because we are kind of humble about what we do, is the fact that we all came together. Not only are we friends, but we came together because we all had some kind of specialized knowledge. And the old adage, knowledge is power. That's a falsity. Go look at Jeopardy. There's no power in all that knowledge they have. Couldn't get them out of a foreclosure or credit card debt, or they have no clue on what the system or how it functions, or that they're sheeple out there. And we kind of got tired of the gurus out there stealing everybody's money. Matter of fact, I heard another story today that Randy, he's on this line, some group with some guy, and I'm not going to mention any names, obviously, but another one, year and a half, this lady called him and says, man, we got doctors, attorneys, we got everybody on here, and at the end of the day, they're not getting anywhere. And it's been a year and a half. I said, geez, a year and a half. Let me see. You could have probably collected $25 grand, $30 grand at a minimum if you tried real hard to do nothing using our system. just off your credit reports, let alone if you're in foreclosure or credit card debt or any of that stuff. So anyway, we got to the point where we got tired of and everybody knows who they are that's out there, the names, $600 for this, $1,500 for that, $3,000 for this. Two things that we always found very intriguing, including myself, because I've never paid any one of these gurus a single penny, and I refuse to, because I'm a very simple person. I say, listen, guys, Larry, if you have this system, and Larry's witness, because we are friends, but when he came to me, he said, Jesse, listen, I think I can incorporate this in, and with our knowledge together, all three of us, we can really put up a good fight in foreclosure. And, of course, we wanted to take it a step further for everybody, but I said, well, Larry, show me the proof. And that was it. It was a simple question. And now he wasn't charging me anything. Okay? Show me the proof. Let me see the checks. Let me see the contracts. Well, some of them, obviously, he couldn't show. But the checks, there you go. There's the checks. There's a copy of all the checks. There's the deposits. Here's the case numbers. You know, that's all I ask. You say you have a system. Before I go peddling it to anybody, even though our system is a whole $99 to join and $49 a month, it's $600 for a year, the bottom line is I'm not going to open my mouth to anybody and say do this or do that without knowing it works. And that was part of the deal. You know, we did this on a doctor client of mine. I did John's a couple years ago. That's it. Done. Okay, it works. That's it. I'm sold.
Yeah, you know, Jeff, one of the things that I was interested in the beginning when I heard about what Larry was doing, my first question was, well, do your pleadings survive the motion to dismiss? Remember I asked you this last year?
Right.
Do they survive the motion to dismiss? And that was our conversation. And then after I heard that, I was like, okay, show me. I want to learn how to do it.
Yeah.
And I want other people to learn how to do it.
Because, you know, we're all, even though we do this for ourselves, I filed 2 more suits today, personally. Yeah, you know. John.
Hey, you got to tell that story a little bit later on in the call too, Jesse, because it's hilarious.
Working feverishly to get that done. Yeah, and I literally had my notary. I went to her house today. I had my notary notarize 21 verified complaints today, so I got them all out of the way. They're done, and I'll just start hammering them now. You know, I warned him. He didn't believe me. I gave him 3 weeks, but regardless, my point is that guys, we never are going to tell you something that doesn't work or try to sell you on anything. I'm not selling you on anything. And neither, I don't believe Larry or these guys are. As much as we'd love to have you as a member and help you, our goal was twofold. Give you something that works 110% of the time. It's all up to you, because you can make it not work by not using it. It's very simple, okay? Second was something that's very cheap that anybody can afford. That was the biggest priority, because we have to eat. John has a family, Larry has a family, and I don't work for free. I'd rather, you know what, I can go fishing, make no money, and be a lot happier. It's that simple. I can work my own cases, make $150,000 a year, and be fishing 4 days a week. I don't have to take calls from anybody. I don't have to monitor forums. I don't have to do the research. But it's something I really enjoy. It's something, you know, my friends, family, everybody knows Jesse loves this stuff. I really enjoy it. Larry likes it. John likes it. You know, it's something we do because it's something we do that. What's the old adage? You do it, it's not love. It's a slave labor to yourself, or whatever. What do you call that? I forget the old. I'm not good at those things, but at the end of the day, we do it because we love it. But I sincerely want to help people. We sincerely want to help people help themselves. It's not a matter of, you know, hey, do this for me. Because if I was going to do it for you, I'd say, hand me a check for $5,000, and I'll do this for you. And I assure you that if you follow our directions step by step, and we'll help you the whole way, you're going to collect $20,000 on this lawsuit. So, hey, you're out 15. You're ahead 15, okay? So you can't complain. Even though you will get the whiners, that's never happy. But at the end of the day, it's minimal amount of money, maximum amount of results. As we tell our members, if you're in our site for 60 to 90 days and you haven't paid for your entire yearly membership, at least with one little $1,000 lawsuit, you're not $300 ahead where you can take your wife and kids to a good dinner, you are doing something wrong. It's not about us. It's about you. So you have to look at yourself. And we're the only guys out there that say, here's the proof. There's the checks. Go look at it. It's all there in front of you. And, by the way, you got a 60-day, 100%, no questions asked, money-back guarantee, because that's just the way our processor that does our credit card processing requires, because of what we do and the information that we're selling. So it's out of our hands. Nobody else out there does that. And everybody here on this phone call, not everybody, but most everybody's been burned, knows somebody who's been burned by thousands of dollars. So I can't go any further than that. Just know that the system, when you use it in combination, is absolutely deadly for foreclosure, cleaning up your credit, getting rid of debt collectors. And I forgot, Larry, I want to make this question or this very clear to everybody, especially Jeff. You were telling me something about what's going on in Colorado, and I'm just going to address it. I've not had a chance to read any of that stuff. Obviously, I've been going since I got home from the courthouse today. The reality is, guys, that any time a debt is assigned or sold, which we know it's never assigned really, okay, it's sold as a debt, like a credit card debt, medical bill, et cetera, et cetera. The reason, remember last week I said those debts can never, ever be sold or assigned. And the reason being is the person who bought that debt can never, ever testify that they have firsthand knowledge on anything on that account. So they can never really step before a courtroom or an officer of that court and testify to anything. They have no witnesses, they have no employees, they have no record handlers, they have nothing. And 99% of the time when you get sued in small claims or in the state court for, $5, $6, $8, $10,000 for a credit card, it's a junk buyer attorney suing you. It's not really. And they've been busted recently, and you guys all know about this, I'm sure. It's not really Discover card. It's not really MasterCard or Visa or Chase. It's generally a debt buyer's attorney who's disguising it as them. So just remember that they have no witnesses. They have no records. They don't have the authenticated records. They have nobody who could authenticate the records. They have nobody who could testify on their behalf. So that's why we always kill them. But that's part of our system. It's very simple. And I know, Jeff, in Colorado you said the state, this and that and the other, but the reality is if you approach this the right way, you can knock them out. And we'll get into the torts and all that stuff later. But anyway, Larry, go ahead and jump in, and then we'll open this up for questions. Once again, before I go, just please, guys, get your questions together tonight. I really want to answer as many questions as we can today. It's something we enjoy doing. And I'm sure it'll help you guys out of any pickles that you might be in immediately. So, but anyway, I'll throw it over to Larry.
Yeah, just to follow up on what you were saying, Jesse, when I first met you and you asked me for proof, because I've filed numerous federal lawsuits and I filed, a couple of state lawsuits, and I'm not anywhere near done. Unfortunately, I don't get a lot of phone calls from collection agencies. I don't get the letters anymore because I think I'm kind of marked and they know to steer clear of me.
They're afraid of you, man.
Huh?
They're afraid of you.
What did you say? They are afraid of me. Not just the collection agencies, but a lot of the attorneys too. But I showed him a judgment that I got against Capital One for $10,000, and they paid me. I showed him a judgment I got against Cavalry for $5,000. They paid me. I showed him, and a lot of these settlements were confidential. So I can't really talk about exactly how much I got and from what company. But I showed him $30,000 worth of checks from other companies, and I couldn't even find 5,000, copies of $5,000 in checks.
Those are on the website actually, so don't forget to mention.
Yeah, those actually are on the website. The redacted versions of those checks. So I've collected somewhere in the neighborhood. I think it's around $75,000 so far. And I got a long way to go because I'm still going to collect a bunch of money from these people. And we're talking collection agencies, we're talking credit bureaus, we're talking the attorneys that represent them. And, like John was saying before, if you're getting collection letters, if you're getting phone calls, as far as I'm concerned, that's money in the bank. And you should welcome it when that happens, because if you use our system, not only are you going to be able to defeat them if they're suing you, but you're also going to beat them when you sue them in federal court, or at least threaten to, because, the laws are there, and we're talking primarily Fair Debt Collection Practices Act, Fair Credit Reporting Act, and Telephone Consumer Protection Act, which is one that we've recently incorporated to a great extent. But those are federal laws, and you have rights under those laws. And if these people violate your rights, then you can collect money from them. And if you do it the right way, and it does take work. We're not going to, pretend it's just, as simple as rolling out of bed. But if you follow the system, just systematically go through it, step by step, then you can collect money from these people, and lots of it.
Larry?
Yeah?
You may want to discuss how this is not about the debt, but rather about their bad behavior, and perhaps use the example of reporting in the credit report.
Sure. Yeah, and that point is made a lot, and that's true. However, there are going to be some instances where you may owe a debt to somebody, and if it's a legitimate debt, and we never advise that you don't pay a legitimate debt or, we certainly never advise that you file a frivolous lawsuit or, testify under oath to something that is not true. But the thing is, you need to make these people prove it. And as Jesse was discussing before, if you're dealing with a debt collector or their attorney, I can almost guarantee you that what they're doing is fraudulent. I mean, I honestly have never seen a situation where I couldn't demonstrate, prove that a lot, if not everything they were doing was completely fraudulent. Either they were attempting to collect a debt that they didn't own, or they had no reason to collect that debt, or they were collecting a wrong amount, or whatever the case was. And this is true for both credit card stuff. It's true for mortgages, and that's a whole other field where basically almost everything out there is fraudulent. And you're seeing more and more information about this coming down the wires all the time. But yeah, as Jeff was saying, it's not about the debt. It's about your rights under federal law. And regardless of whether you owe somebody something, if they violate your rights, if they call you and threaten you, if they report false information to the credit bureaus, if they, repeatedly harass you, then you do have rights, and those are worth money to you under federal and usually state law as well.
Let me add to that, Larry. Can you hear me, Larry?
Yes.
Yep.
Okay, the reality is, guys, that if you owe $3,000 or $4,000 or $5,000 on a credit card that they say you owe, and Joe Junk Buyer buys his debt, the chances of them violating the FDCPA, your state acts, like for instance here in Florida it's the FCCPA, in Georgia it's the Georgia, what is that again, the Georgia Debt Collection Practices Act. They're all very similar in verbiage. California's the only one that has a weird one, but really, they already owe you more than you owe them. And either two things are going to happen. You're going to get a check, or the case is going to go away, or both. That's the worst of the outcomes, literally. Debt goes away, check, or check and debt goes away. That's it. There is no other alternatives there. So that's why we encourage people to immediately sue. Don't ask so many questions. Jump on there, get in it, push them, let them know you're not going to play their games, and take action. And once again, our system gives you the tools that are effective. It gives you everything you need to really, really put these guys on the hurt. And that's all we can say. I'd love to open this up for questions.
Okay.
Hey, can I just make a couple of points because you hit on it?
Sure.
Sue early, sue often, and well, I mean the thing is that Jesse has pretty much mastered the strategy of just suing every time they violate the law. I mean separately in both federal and state court. And maybe he'll tell you the story about what he's working on now. He gave you a little hint about it. But the other thing that we really push to people, and I do it all the time, and I love doing it, is to sue attorneys and their law firms, because that's when you really, that's when you really do some damage. And when they realize, the attorneys are getting sued, and, maybe they drop out of the case, maybe they proceed, and even as they proceed in this case, they're still continuing to violate. You keep suing them because they will violate the law. I can guarantee it. I've never seen them not do it. And we've even developed a couple of strategies, and Jesse can tell you about this, where you're suing, let's say, a debt collector, and their attorney, even though you're suing them, they're not going after any money necessarily, but there's a couple of ways, and I found one and Jesse's found one, where you can actually sue the attorneys and have a viable case against the attorney representing them when they're defending. And it's just incredible because
they love you for it.
Yeah, they love you for it. Please tell them what you're doing today. What was the lawsuit that you filed, Jesse?
I got a box of chocolates from the attorney for filing that suit today. But here's the
right.
Here's what I know. Jeff called me. I told him I'm sorry I couldn't answer, but I was actually filing. I was in the courthouse rushing to get there before the deadline. But anyway, the reality is this particular debt collector, it's Apex. There's several of them. There's Apex. Now I'll give you a little explanation. You got Apex, you got Nation Star Mortgage, and you got Equitable Finance, which Equitable Finance and Apex are the same company. They just didn't know that I would know that. So long story short, I have a lawsuit in the federal court right now for over $350,000 against Citibank for violations of the TCPA. But remember, what happens is when they violate the Telephone Communication Practices Act, it's automatic violation, and you allege this, of the federal and the state. So I learned my lesson because we're having a big conference call Thursday morning, all the attorneys with Citibank and myself Thursday morning to resolve some issues. But what I learned was that lawsuit is I stuck all the phone calls, all 57 of them in there. I stuck every count under the FDCPA that you can imagine and every state count that you can imagine. And the chances of me winning the case are, 95 to 98% for what I'm asking. Now, will I get something out of it? Heck, for Thursday, as far as I know, they might say, here's 50 grand, would you just go away? Here's 10 grand, 5 grand, I don't know. But I learned something very important from that. And I thought, Larry, I'm just going to switch this around on Apex. And here's where Apex gets in. Well, let me stick with Citi. Citi allegedly sold this credit line to NationStar. Well, NationStar Mortgage started calling my cell phone. Well, Citi never told them that I had them in federal court over that matter of calling my cell phone. Citi has yet to prove how they acquired this loan, the alleged credit line. No assignment, so they're in violation of TILA, which I'm going to let them know on Thursday. I'm going to file a suit probably Friday or Monday for TILA violations, which you can do, and the judge can enjoin it. The whole separate cause of action doesn't matter. I'm going to do that. But so NationStar started calling my cell phone. I let 11 calls rack up. And what I did is I took each call, and I said, okay, I'm going to take the TCPA, which is the Telephone Communications Act, Practices Act. Even though it's a federal act, the state has exclusive jurisdiction over it, period. They want you. As a matter of fact, the verbiage specifically says they want you to settle it in small claims. And I thought, wow, this is pretty slick. Let me reformulate this. I ran it by Larry. Larry says, well, what the hell? Sounds fun. So I take each phone call, and I sue them into small claims for the $1,500. 2 counts under the TCPA. I know one is going to be bogus, meaning it's not a bogus allegation. I mean, I'm not going to get paid for it. But I can allege it. There's nothing wrong with that. So I'm going to allege $1,500 for that first part, $1,500 for the second part, $1,000 for the state act. So it's going to be $4,000 per claim. Okay? And I know a lot of people have asked, well, Jesse, what happens when you file in the small claims and you file 10 lawsuits there, and then I go up to the federal and I file 10 there for the FDCPA? Well, if a judge were to look at me and say, I'm going to enjoin these, or why are you filing so many cases? The reality is, listen, if you enjoin these cases, you're prejudicing me. Why? Because, number one, they're all separate causes of action. I can file separate cases, and I have 4 years to do so. So worst case, if you're going to try to enjoin these, I'll drop the remaining 9 cases, and I'll wait till this one's settled, then I'll file another. I have 4 years. I'm not in a hurry. I got 4 years on TCPA, a year on FDCPA, and 2 on the state. So I'll keep it within the time frames. But number 2, you're prejudicing me. Why? Because each call is a separate cause of action. Each call is a violation of the Florida Act. If you were to enjoin all 10, you'd cost me $9,000. That's where the prejudice is. I'm entitled to bring them in as separate causes of action under simplicity. So I'm telling the judge, because I know I'm going to have to go in front of Judge Draper out here in my county, and the woman's awesome, as long as you know what you're doing. If you don't know what you're doing, she'll treat you like a dirtbag. But if you know what you're doing, never lost a case in that court, and been in front of her 6 or 7 times on various matters, foreclosure case, credit cards, like I said, various matters. Never lost. Why? Because my paperwork's simple. My motions are very short and right to the point. Don't even have to open my mouth hardly. This is it. ABC, done. Okay, thank you. Have a good day. And we're out of there. So the trick is to keep them super busy, because now I'm going to file this in the small claims, and then I'm going to file in the federal. Well, generally a federal attorney, God forbid, show up in a small claims court. That's unheard of. It can happen. It happened to me 2 weeks ago. I went in for a mediation. Last week. I went in for a mediation. Lo and behold, there's a Fed attorney there. What in the hell are you doing here? I asked him. That's exactly how I said it to him. He says, man, I don't know how I got stuck down here today, but I got to take care of this for this client that you're suing. And the guy flat out asked me, he looked at my paperwork, because he hadn't even seen my complaint yet. And he looked at it, he said, do you have a copy I could use or see? I said, sure. He looked at it, and he looked right up at me. He says, how many times have you, or he says, do you do these very often? I said, no, this is my first one. And I just chuckled. And he says, man, that's excellent. That's an excellent complaint. He says, I do prosecute these in federal court, not just defend them. I prosecute them. I said, that's great. And then I handed him, because it was the day after Larry, I handed him what I had found in the Act, in the Fair Credit Reporting Act. And I showed him, and I said, here, this is how you're going to kill everyone you prosecute. And he looks at it and he goes, holy Toledo. He couldn't believe it. And here is a, what do you call that lady that's in there doing nothing really? What do you call her? Mediator?
The judge?
No, it's a mediator because it's small claims. But she was like twiddling her thumbs, the attorney and I are talking about strategies and all this other stuff. Anyway, long story short, man, here's a Fed attorney in the damn small claims, but you're keeping them really busy. And here's why you win 99% of these things without ever stepping into court. First of all, in the federal court, you never go to court. If you do, it's such a rarity, it's crazy. In the small claims court, you're supposed to go to mediation prior, at least here and in most places in the country is the same way. Then from there, you head off to either a non-jury trial or a jury trial, 30 to 40, 50 days later. But 99.9% of the time, they want to settle right then and right there at that mediation. So if you're asking for $3,000, they'll try to get you halfway or 80% or whatever. If you don't want to bother or you need the money or you're in a hurry to get the money and get out of there, go for it. Because that's what we tell people. If you don't have a lot of money for filing fees, get your first case. Settle for 50, 60, 80 cents on the dollar. Take that money, reinvest it right into it because it's an investment right into the next case. And keep the ball rolling. Okay? I'll tell you this. One of the listeners on this call using our system has kept himself out of foreclosure now for, I want to go on 2 years, over 2 years. Literally, they just dropped the case altogether. Now, again, he got, it's a non-judicial state. He got paperwork today. He sent it to me. He's a good friend of mine. And now we're just going to sue that attorney. Because, once again, he went to public records. There's nothing there reflecting a transfer to Bank of America. We all know Bank of America is in the middle of settling these fraud suit issues that they have. So we're going to sue the new trustee. We're going to sue the attorney who's bringing the action. We're going to sue under the FDCPA, trying to collect an alleged debt, attempting to collect an alleged debt, and under the State Act. And let's see how they act. I guarantee you that trustee is going to scatter, say, I don't want nothing to do with this damn case. Because now I'm being sued because you guys said he can't come in and file a motion to dismiss because there's nothing in public record to support him. So there's nothing in that public record. And under TILA, there has to be that way he could say, oh, well, yes, I'm here. I have the right to foreclose. Look, it was assigned in 2008. No, sorry, doesn't work. They got nothing. So they'll survive that motion to dismiss, and we'll get them hammered. So, but enough. Anyway, let's open this thing up to questions, Jeff.
Okay. And for those of you who have questions, you press *6. Again, that's *6 to raise your hand, and I would be just absolutely positively delighted to recognize you. Okay, Dee's got a question, so let's go with Dee. You're live, Dee.
Yes. Hi there. I just recently joined up with the service, and so basically, a lot of what you guys are going through, I have several things that are in progress right now, and I also have one judgment, and so I'm just like brand new to this, and I'm wondering is when a judgment's already been served against you from one of these credit card companies or something, is there a way to reverse that?
Well, there's kind of a couple of ways of dealing with that. The hardest is to vacate that judgment, and that's a whole long process, and there's certainly ways that it can happen, at least in theory. The court system itself is likely going to fight you on that, but that's something you want to look into. I know we have some information about that on the website. We're certainly going to add more to it, but the other way to deal with it is, once again, and depending on how old the judgment is to go ahead and sue everybody involved in that judgment. And if you can do it within a year, because that's the statute of limitations for Fair Debt Collection Practices Act, that would be ideal. But if you can demonstrate that they've broken the law, the FDCPA, in collecting or actually obtaining that judgment, which, at least in theory, say what? I
said reporting negative information on his credit. I mean, you could use the FCRA, the FDCPA. and a state act. You got all three in your favor as long as the statute of limitations hasn't run out.
Right, absolutely. And, statute of limitations, FCRA, is much longer than FDCPA. So, again, the trick is, use the system, even if you have a judgment against you, and look for ways that they violated any number of state laws. And go ahead and file, and chances are you're going to get more money from them than they'll have ever obtained from you. And then, of course, if you're using John's system, you're protecting your money at the same time. So it's a combination of things, and you just have to pick and choose what works best for you under your particular circumstances.
What I would suggest to get the judgment, get the case file, and go back and look at the original complaint and see what attorney and law firm signed on, and track it as it progressed and see which attorneys were there, and if there's a name of a law firm like so-and-so PA or something like that, go look them up on the Internet and find out who the general partner is. So these are all defendants. Every attorney that's
John, why don't you just tell them what you just did in your foreclosure after 3.5, 4 years, and where they're stuck. And that way you can get an understanding of these little tricks that we show everybody, and what the possible results will be, but it's all up to you guys. You can't count on everybody else, and that's part of the problem. Everybody spends all this money and then drops everything, their problem, on somebody else. And then somebody else lets them down, and that person is no good anymore. So bear that in mind. You have to take the responsibility.
Yeah. In this one example, not including creditors and debt collectors in my own foreclosure, there's 16 attorneys right now, all involved. They're all trying to take the title to my property, and they can't go anywhere. And they're all defendants now. At some point, they all have some sort of liability.
But where are they defendants at? And what did you do? I want you to tell them where they're at now, why they're there.
Well, I didn't feel like going to a hearing in December, so I just removed the whole thing to Fed court, and the idiots didn't object. So now they're stuck there. And now they have to deal with my counterclaim. So, and they start bringing all these attorneys filing notices of appearance. Every time they file a notice of appearance, I got 3 new defendants.
and the funny thing is, yeah, because John told me about this, I guess, about a week or so ago, and I said, well, you can't remove that to federal court. There are no federal issues there. And that's actually true. But the problem is they didn't object to it within the 30 days that they were obligated to, so now they're stuck. And, you're going to have attorneys who screw up, and it happens all the time. And if you know what you're doing, if you can read the rules, if you can read the law, then chances are, 80% of the time you're going to be able to beat an attorney because you know more than they do. And in this particular situation, John didn't know, but it turns out, through his lack of knowledge at the time, he actually he did himself a huge favor. Yeah, I didn't know. I was just trying to cancel a hearing. I didn't know I'd get him up there, and I didn't realize they would overlook not objecting. But what I was saying,
it was Christmas, John. They were busy.
I guess so. But on the judgment lien, go through and look at scour the records, see if they put in an affidavit. Sometimes they'll put in an affidavit and ask for summary judgment. All right, look to see who signed the affidavit. Not the notary, but the witness for the bank. Find every attorney you can find, name the creditor, anybody else who's involved, pull your credit file, see who else was connected to that account. So on that judgment lien, you might have 8 or 9 defendants. Now you go into Fed court, provided you're within the statute of limitations, and you just see how it works. They might owe you more than
It just think back to high school, your first dance. If you don't get out there and dance, you're never going to know what it's like to dance. You just got to do it, and it's a lot of fun. And you're a new member. You can hopefully you can vouch how much information is on that site. Literally.
Beautiful. Thank you, guys.
Tutorials. It's just we try to make it no offending, or I'm not trying to offend anybody. A 6th grade understanding, because we know it's complicated. We've gotten the bumps, the bruises, the black eyes, and the broken ribs through the years, so we know. Okay, well, damn, I didn't read that right, or I didn't understand right. But as I told Jeffrey today. I can glean information from the worst of decisions, because the judges are always telling you why you screwed up or why the other person screwed up. And if you can learn to glean that versus going, oh, that's a bad decision. No, sit down, read it, and glean from it, because you're going to be told exactly what to do next time to win, and that's the beauty of it. And that's where we try to, at least that's where I try to concentrate on all my studies and my research is go through cases, good or bad, it doesn't matter. I find good stuff, I find bad stuff, and I think, wow, that was just a flat-out bad decision. But then when you read the case, sometimes you'll find some amazing information, and you go, well, no wonder this dummy lost the case. He didn't do this, this, or this. It was so simple, and he got outwitted. So, you know, the information that's on the site, we try to keep it up to date. We've got fresh news every day and complaints and templates. We're always doing something. But we had to slow down the webinars, guys. We were doing 3 a week plus this call, and it's just overwhelming for people. I mean, literally, it was just overwhelming. So we got down to 1 webinar a week, 1 call on Tuesday, which is open to anybody and everybody to get out there. And then we're going to start an affiliate program here soon. We haven't decided how we're going to do it, but we are going to do it, and that'll give you another chance to make a little money on the side. So, but anyway, next question, guys.
Okay, thank you, Dee. We got
thanks, Dee.
We got Jim.
Yeah,
in Utah.
Thanks, Jeff. I have kind of a 2-part question. I have 3 judgments against me from debt collectors, and I believe they're, well, one of them's about 5 years old, one of them's about 3 years old, the other one might be 2 years old, and I have 2 garnishments from these judgments. One debt collection attorney has been taking 25% of my paycheck for over 2 years. My question is, I'm pretty sure the statute of limitations is gone, but I was told about equitable tolling at a previous provider, whatever. What I guess my question is, how does or effective is equitable tolling when used in conjunction with TILA or the Fair Debt Collection Act, and is that a way that I could salvage and come after these guys? Is that a viable way?
Well, let me give you some good news and some bad news. The bad news is the FDCPA is quite strict on its statute of limitations, so it's 1 year period. However, the good news is that 1 year extends back to any action they have taken to collect an alleged debt. So that means if they are collecting through a garnishment, every time they do that, that is a potential violation of FDCPA. You can look into your state acts. So in order to attack those judgments itself, you have to find a way to vacate them, and that's a pretty tough row to hoe. However, if you want to go after them directly, you can go after the company, you can go after the attorneys, you can go after the law firm, you can go after the partners, whatever. When you're dealing with these garnishments, as I said, every time they do that, if they violate any portion of the law, if you can demonstrate that they had no right to the judgment originally, even though you can't get damages from the judgment itself, you can show, particularly in federal court, that they're continuing to violate because they're attempting to collect either illegitimate debt or an amount that's wrong, or that maybe they did something wrong and even getting that garnishment in the first place, which happens all the time.
Yeah, Larry, I want to chime in, and actually, John, you should chime in because through John's method, we had an IRS garnishment removed a month and a half ago, and we had another SunTrust garnishment removed. Same doctor friend of ours, by the way. And John did it, and his guys, how you tell him, John? I mean, one of them, the IRS, was done in, what was that, 2 days, 3 days?
Well, the IRS is immediate. I mean, you download a form and you fill it out and mail it in, and it's done. And then they
they got their money back, though. Make sure you say, make sure that you, yeah, they sent them back a check, by the way.
But the judgment, the garnishment, what we did in Florida, it just so happened that we have a homestead, head of household exemption.
Head of household.
Yeah, head of household. So
now, how many people in Florida don't know this exists and these attorneys abuse it? If you're head of household, you're done. They cannot garnish your wage. End of story.
Yep.
And they do it day in, day out.
Yeah, you can pretty much claim to be head of household and be head of household. And it's a one-page document. You file it, you go to a hearing, the judge asks you 3 questions, and that's it. And they know it. The attorneys know that that's what's up. So you don't want to look at your state laws. You want to look at your state laws. I don't know what state you're in. See if
Utah.
you have
Utah.
Utah. Okay.
Yeah.
So see if there's some sort of head of household exemption. And usually they won't notice you of that, so you have to do some keyword searching on the internet. I would start there, and you might be able to stop them at that point. What we do is, you'll find out in the system if you want to get the procedures. Is what we do is we create a judgment lien like they have, but we make your plaintiff friendly to you. So you get a friend or somebody to do it, and they get a judgment against you. And then when you have your judgment lien in place and you have all your wage garnishment papers filled out, you file a bankruptcy, get a case number, serve them, stop their garnishment. Then you withdraw your bankruptcy and you file your garnishment in front of theirs, and that'll block them, and they'll never be able to garnish your check again.
Does that make sense?
Yeah. So that's
now.
how there's a way to stop them there, but I'd like to go after the money. Go to the oldest within the statute of limitations collection effort.
Well, Larry, wouldn't he be able to go back from the date of discovery 4 years on the FCRA for if case these attorneys or this company was reporting derogatory information?
Yeah, well, actually, it's 2 years from date of discovery on FCRA. So, and this is one of the things. This is one of the key things that we recommend when you join the website. Get all of your credit reports, check it carefully, start disputing things that shouldn't be there, and look for inquiries, both hard and soft inquiries by anybody who shouldn't be pulling your credit. And that means attorneys, debt collectors, and actually even your creditors. And this is something that Jesse just found, which nobody I don't think has ever discovered before, that unless you have a bank account, your credit card company shouldn't even be pulling your credit, even to check it as an account review. But the key is, and John pretty much made the point, if you have to be on the defensive in certain instances, then do that, protect yourself. But by far the best way to go about this is to be on the offensive.
Yeah, that was part of the reason of the development of the program was I got tired of attorneys. And Lord knows, listen, I have a lot of attorney friends. Matter of fact, John's federal firm that's handling the case that's helping those other, one of the attorneys in that firm is a very good, dear friend, family friend of mine for over 10 years. And he knows I'm a pit bull. He knows it. And he loves it. But very few of them will do what we tell them, meaning, you're my attorney, Larry. And I tell you, Larry, sue that attorney. Oh, I'm not going to do that. You can't sue that attorney. Because right off the bat, they don't want to do that, but that's what you have to do. So that's prejudicing you right off of the bat, and they'll never, ever admit that to you. Oh, don't listen to those guys. They're not attorneys. They don't know anything. Da-da-da-da-da. Well, sue one and see what happens. You'll see how fast that guy quits acting like a jerk and starts handling his business the way he's supposed to handle his business. And this is what we're saying, that a lot of the people who run out and pay these big bucks for these attorneys, at the end of the day, get nothing. I don't blame people if they feel a little insecure about foreclosure. They want to go ahead and hire an attorney for the foreclosure just to help them out. But make sure that as you've hired an attorney and you're a member in our system, you're learning from us and you're taking it right back to the attorney and saying, hey, listen, did you know that under TILA, da-da-da-da-da, and here it is, and I want you to sue them for it. And did you know that under the FDCPA, ABCDDD, you can do that, and I want you to do it. Because now if he don't do it, you can come after him for malpractice. So you have to have something. You can't just be the poor, dumb, innocent homeowner. You need to be the person who takes the responsibility and says, you know what, I don't want to be in court. I'm going to let an attorney handle it. I might not be good at articulating things. I might not be good at arguing or bringing the point up. But dang it, if you learn something, take it to that attorney and say, listen, I want you to use this. This is the law. And all of a sudden, that attorney will start paying attention to you. Trust me, I used to do it all the time. So it's one of those situations that we've created a system to help. And I think that John's friends is we have a couple of attorneys that are members anyway. But at the end of the day, the reality is that there's a lot of things out there that you can use that attorneys aren't aware of. And remember, this foreclosure battle and this foreclosure fight has only been going on for a couple of years in the open. Okay, these attorneys, how many foreclosure attorneys were there just 2 years ago? Nobody. I could never find them. Now there's thousands of them everywhere. Just look on the internet. Everybody switched gears. And they went into defending foreclosure. Well, they don't know nothing. It's the guys that have been around, like John or Larry or myself, for 7, 8, 9 years doing this stuff. And I'm not saying we know more than them. What I'm saying is that we already been there, done that. We've got those bumps and bruises. So we know what works and what don't work, what you can bring to a judge, what you can't bring to a judge, what a judge wants you to bring to him. So anyway, I hope that helped you, man. And John, let's run to the next question.
All right.
Okay, thank you, Jim. We're now moving to Tom in Minnesota.
Hi. Do I need a punch anything?
Not Tom.
I was going to say, that doesn't sound like a Tom to me.
Well, Tom girl, whatever. Tomboy, whatever. See, I'm kind of curious because we were advised to get onto the call by a friend of ours, and we're wondering if any of you guys know who Paul Capel is.
I don't know. No. I don't know the name.
Okay. He thought that you might have some extra direction for us. And we have a lot going up in Minnesota because it's, non-judicial state, and we've basically found out that there's the foxes in the hen house here, and in
they're
regards
everywhere.
it's foreclosure, and most every public official seems to have their hand in the cookie jar.
Yep.
And our due process rights have been pummeled by, like you said, the third-party interloper, attorney, law firm, and public officials acting, out of their job scopes to steal the properties from people that they don't own, and ours was one of them. But we have so much going on that I don't know if it's the place to take up on this phone call, and I'm wondering who out of the three of you would be the best to maybe set up a time to just chit-chat with for, I don't know, soon for maybe half.
Jeff, generally we do not chit-chat with any member.
Okay.
We try to keep that at a distance, and the reason we do that is very simple. When you get up to the level of membership, how do you handle all this? It's more of calls like this where we can answer some questions, give you some guidance. But I'll tell you, Minnesota is no less or more crooked than Florida.
Yeah, and well, the thing is that
it's the same. The difference is they're non-judicial. How do you stop that non-judicial foreclosure immediately? This is what people don't realize. They run out there, and we have TROs on our site. You can have a restraining order. You can sue the suckers immediately into the federal court.
Right, and that's what we're working on. But we do have a couple questions. One is money's been tight because we've got hundreds of affidavits in the record, and everything that we've done, we've recorded, so we've made public record of it. We've used a notary. We've done everything, cease and desist. We've contacted, all sorts of public entities that are every public official that's supposed to act on the behalf. And, of course, they do nothing but agree with everything by not responding. Their silence is agreement. We've gained lien rights on them and every lender. We've got overwhelming proof of security fraud and, even from the day of the supposed bogus closing, the note was sold 4 times with 4 different lenders, 4 different payment slips, and 4 different account numbers, and they still move forward, and not one would ever come and say, hey, I see what you're saying,
Right,
we went to the examiners, the titles, actually had have a land patent, original land patent on the property, recorded in the record, and they still move forward to remove that.
All that stuff is under FDCPA. There's actual damages. There's penalties. You're wasting your time with all these liens and stuff. You got to bring them into Fed court and get an injunction.
Okay.
That's where you got to focus and do that.
I'm just going to make something, and John, you're absolutely correct. Listen, there are so many things and I want to use the word peddled out there. You've heard me say I've not paid a penny for anything because when I say, listen, I love the idea of the land patent. I love that idea of the federal land patent. As a matter of fact, Disney World right here in Florida has a federal land patent on their land. That's why they have their own police departments and their own da-da-da. I hear the stories. Oh, they don't come onto my property, I'm afraid. But then here you go. You're the exact example or the oldest example I'm looking for because I've heard the stories of the land patent. Oh, I'm living like on my own island. The feds are sitting at the gate, but they won't come in. And here you're telling me, don't matter, they're moving forward. You see my point?
Yeah, no,
and I know people selling that land patent for $1,500, $2,000. I'm like, what? You know. Listen,
no, we didn't pay that kind of money for it. But you know, we do have it. But my point is, you paid something. Yeah, and it's not working. Right, nothing. Yeah, nothing worked, and and it's the public officials. Honestly, it's the sheriff is supposed to have some type of lawful authority, which we know he don't work for the people. He works for, whatever, not us, the corporation.
The public policy. That's right. He's not there for you.
Right, and so we can see through the dotted lines. I mean, it's pretty evident now.
Not to be rude.
Yeah.
But I'm going to stop you here. The power that's behind the FDCPA is that
people don't realize that, but
the Supreme Court ruling in January 2010 basically said that the creditor who loses is liable for actual costs.
Mm-hmm.
And in the case of a foreclosure, that's the amount that you have paid for the note so far and the fruit of the note. You don't think that's going to stop a foreclosing attorney?
No.
It will.
So you've been dealing
because he becomes liable for it.
Okay. No, I hear you. I'm sorry. I meant to say yes in regards to that. Yeah.
Yeah. Are you dealing in the state courts?
Where you were at, it didn't stop him. It didn't matter how many times we went to him in the lower courts. And we are, like we said, but the problem here is, Minnesota, I don't know. I don't know what Florida's like, but like we said, it's corrupt.
Bad. We have one of the worst bars in the whole nation. Everybody knows this. I mean, hell, the National Bar or National Board of Bars or whatever voted Florida the most crooked bar in the country in 2008. And that's their own people. So, yes, we're dealing with the same thing. What you're not hearing is Fed court. The Fed court has nothing to do with the state court. The Fed court is a ballroom dance.
Okay.
You court each other. You go through there doing things appropriately. It's not the state kangaroo courts where these monkey judges are doing whatever they want to do.
Mm-hmm.
And that's the beauty here in Florida. We have judges here in the last 3 months have said, publicly came out in orders, we are not going to enforce the Florida Rule of Civil Procedure in its 1.54. We're not going to enforce this. We are not going to enforce that they have to bring in all the attachments when they sign an affidavit for summary judgment of costs and fees. What do you mean you're not going to enforce the law? And they blatantly said it. We're not doing it. That's how bad it is here. They've told the public here in Florida, we don't care. We're not making the banks do it. How's that?
And this was after the Florida Supreme Court ordered all the courts in the state to do that.
Yes. So, when you talk about crooked, we have crooked. But once again, I tell people small claims, or federal court. Stay out of the state. Now, you can win in the state. Don't get me wrong.
No, not in Minnesota. You won't. Not after. No, they know all about.
It's very rare. See, I don't care where you're at, what state you're in. It's very rare. So that attorney, when you sue that attorney in a federal court,
you're
an animal.
Well, they all need to go. It's like they can.
Oh yeah, of course. Yeah, that's a no-brainer though. Yeah, everybody does that. We got rid of everybody. And we say that easily. Everybody's got to go, but who has the solution?
Right.
And that's the reality. Before we can all say to each other, the whole system's screwed up, needs to collapse and reset itself. Great.
Oh.
But how are we going to run the whole show? How are we going to do this?
We got to open up the can.
Somebody has to have a problem.
Like you said, up the federal can and drop all the lawyers in there that are involved in the foreclosures because, you said, they're just collection agents. One day they're the agent, next day they're the vice president, then they work for Mears, then they're the attorney.
Listen, I'm going to tell you something that'll make you sleep good tonight. And I said this a couple of weeks ago, not on one of the calls. I think I did on one of the calls, but it was one of our private calls for our membership. The judges' retirements are depreciating faster than people's homes as we speak.
Oh, no.
So that'll make you sleep good, see? Now you know why they're desperately trying to help the banks, because you know what? They're going to retire with nothing.
Well, Black's Law Dictionary.
Of course. It's all, every one of them's on our site.
Right. Well, what does bench mean? It means bank.
Yeah.
Sitting on the bank.
So just remember that. They're losing money left and right, these judges. And these clerks and everybody else. The Orange County Courthouse alone is a private corporation. I mean, you can look it up on Dun & Bradstreet. It has invested $7.2 billion in mortgage-backed securities. Hello?
Yeah.
It's gone. All right, hate to cut you off, but we got to get, it's almost top of the hour, and we try to keep these things at an hour.
Okay.
We want to get to the next caller. God bless you.
Thank you.
Go join up. I think there's stuff there that definitely will move you in the right direction. So.
Whoops. All right.
All right, Jeff. Don't be cutting anybody off.
Let me recapture her.
Hello, you there?
Hello.
Okay, this is Simon. I'm calling. I just need a website, the membership fee, and can you use your system for post foreclosures?
For what? I'm sorry?
Post foreclosure.
For a boat foreclosure?
Close
POST.
afterwards.
Yes, afterwards.
I can't hear both of you. I'm sorry.
Post foreclosure.
Oh, absolutely.
POST.
Absolutely. Pre, during, and post.
I just need your website, the membership fee information. I get off the line. I'm sold. Because I have litigation going on.
Nothing. Now, you got the link. You should have got the link. And we don't like to say we don't know who's on this phone call, so we don't like to.
Okay. I got the link. I'll look back at my email. Okay.
Yeah,
okay.
Check your email. It's all there. And if you don't, please call Jeff back or wherever he'll get you on, because we don't like to say last names and all that stuff.
No problem. No problem.
On our private calls, we know who's there, but on these, we don't know. So
I'm enjoying it. Go back to your call. Thank you.
Okay, thank you. All right, Karen, I shortchanged you. I'm sorry.
Hey, you guys there?
Yes.
Well, we're all here, Karen. He's just trigger finger.
This is your problem child.
How you doing, Karen? You got my message.
I'm hanging in there. I took one big deep breath and sucked all this information in. And a couple of things I had posted, you said, this is a two-part question. You said I'm telling them too much. So I'm just going to go back and re-listen to that's why I love those webinars, to just look at it all again, to do that. And I'm just going to file. And see.
There you go, girl. I love it. Yep.
And see where everything lands. But I have something in front of me that I know you all will love to chew on. I got a response from Lytton for the QWR that I sent to them, and and over again in this letter, they tell me that I'm looking at a sentence here that says, furthermore, because we are the loan servicer and not the lender. They tell me they're not the lender like 25 times in this loan, and they tell me they don't have truth in lending information because they're not the lender, and they told me that the loan is not owned by them. It's owned by somebody I've never even heard of, and that's not in any of the documentations of my mortgage.
Is it in public record?
No. That's what I'm saying.
Remember I gave you that assignment 2 months ago. I gave everybody the assignment. Go to public record.
I did my homework.
Working on that.
Yeah, I did my homework. I went to public records. I pulled everything that they have, and there's only, as far as this loan is concerned, there were one assignment from CTX, who I bought it from, and they sold it to Fleet, and there's nothing else in public record. And they also put a summary in reference to the loan. It says the following is a brief chronological history of your loan to assist you in reviewing your loan transaction. It says, and we provide you with information sufficient to validating the debt. In addition, we have enclosed a copy of the fixed rate note, deed to secure debt, truth in lending disclosure statement, and HUD number 1 settlement statement for the loan. And everything that they have listed here is not in public record at all.
Thank you. And you know Tilla, so get to work.
Yeah, it's not in public record at all. But
remember,
the question
we can
I
never
have
give legal
for you
advice, right?
Is the people that they said in here that hold the loan, should I send them a qualified written request?
Absolutely not. You don't even know them. Have you ever paid them a penny?
No.
Have they ever contacted you?
No, they have never contacted me. It says the current beneficial holder of the loan is U.S. Bank National Association. Never heard of them.
Oh, yeah, as trustee for certificate holder, who knows what. You don't know them. You don't care about them.
And that leads into, and I don't think we're going to get into it too much now, but that leads into one of the strategies we're developing, which is quiet title. And if you can't identify who owns the alleged, the note on your property, then you should be able to take that property free and clear. But what Karen was referring to with a QWR, just so everybody knows, is a qualified written request under the Real Estate Settlement Practices Act, RESPA. And that's a letter that you can send to the servicer of your mortgage and basically demand that they answer questions and correct any mistakes. And I guarantee you that they will either not respond appropriately or they will give you information that's false. I just can't imagine that they're going to do something else. And even if they give you the best information they have, it's going to be false.
It's still false.
So, you're setting them up for a federal case because RESPA does have, you can sue in federal court under RESPA the servicer.
Okay, well, I'm ready. I'm waiting to hear. This is a second mortgage, and they also told me at the end of it that it was in the charge-off department. What is that?
I wouldn't do anything.
That means you're about to foreclose on the note.
Well, they're charge it off the amount. Listen, I have a credit line with Chase that is 5 years old. $147,000. They just sent me a letter saying, "Hey, we'll take $17,000 for it." They've put me in court twice. I've run off both of the attorneys. They've literally withdrawn from the case. So it's one filing, and they've left. They're like, "I'm not going to deal with this." So, they're negotiating out there. They're charging it off, and they'll probably sell it. When they try to sell it, that's when you got them immediately. So I wouldn't. I just, let lying dogs lay or laying dogs. I told you I'm not good with those.
Sleeping dogs lie.
Sleeping dogs lie. I told you I'm not good with it. So I'd leave it alone. If they're calling you, harassing you, make sure you keep it. You keep a nice file with that lit in there. You got all the documentation to prove that they said we don't own it. We don't own it. We don't own it. They claim that somebody else owns it. Who the hell is the U.S.? You don't know who they are.
They're still sending me statements. They don't own it.
Exactly. So that's good. Just relax and chill. Just chill out and.
I've only gotten one response from Chase so far.
Good.
And Jesse doesn't always toot his horn the way I think he should, but he's worked with hundreds of people who are in foreclosure situations, and not a single one of them has lost their home. And basically what happens...
133 active cases that go back as far as 5 years that I personally have helped and handled one-on-one with the people right here in Central Florida, and not a single one of them is out of their home. Not a one.
Yeah, and basically what happens with what he's done in the past is he has them file stuff that will just end the foreclosure case, or at least put it in permanent hiatus where nothing is happening. But as I said, we're working on strategies where we're going to go one step beyond that and get people their houses. If nobody can come forth and prove that you owe them money, then why are you paying money to anybody? That's the question. And why are they threatening you to foreclose in your house or, whatever they're doing?
Exactly.
Okay, thank you guys.
All right, Karen, God bless you, sweetheart. I'll see you on the side.
All right, we got Bob up. Bob in Georgia.
Yes, good evening. I have some questions on assignment of security deed. I joined last week. I wore your website out with the archived stuff, and I went to the courthouse, got my assignment of security deed, which they did after I filed a bankruptcy, skeleton bankruptcy. But they finally assigned the security deed, and my questions, can MERS represent themselves as acting for the loan originator, which is South Star Funding, when they're out?
No, I just answered your question. No.
Okay,
period.
Good.
MERS lends nothing. MERS collects nothing. MERS is a mere straw man.
Okay.
That's not
right.
And in MERS' new policy, and this has been really in development for the last few years, that they should not be the plaintiff in any lawsuit.
Yep.
Right.
Didn't they receive orders from Fannie Mae to not do that?
Yes, they sure did, Jeff.
Yeah, they're no longer the plaintiff. What they did was they assigned not just the mortgage, but also the note to Deutsche Bank.
All right, well, that's fraud, pure and simple. They can't assign something that they never had control or ownership of.
Yeah, the two people who signed it are assistant secretaries, supposedly for MERS, and they actually work for Litton and Prominus Solutions, who's actually they prepared the assignment. I mean,
yeah, there's thousands and thousands of those assistant secretaries and vice presidents and this, that, and the other thing of mirrors, and it's all a complete sham.
Yeah.
You did the check, right? You've run the names like we've told you for the robo-signers. You've went through our robo-signer list and all the depositions we have on the site, Aaron?
Yeah, I've got their phone
so you want to sue all of them. You want to sue them all under the FDCPA for trying to collect an alleged temp or threatening to collect an alleged debt that they know they're not entitled to collect.
Yeah. Well,
see how strong the FDCPA is? You can come in there with fraud. You can come in there with RICO. We even have some RICO stuff on our. Just keep it simple, stupid. You're trying to collect something you know that you can't collect. Who the hell are you, Mrs. Karen Jones, over here saying you're vice president of this or vice president of that? And who are you over here as vice president of this or vice president of that? Sue them all.
Right.
That's it.
Okay. Is a corporate seal necessary on an assignment like that? Because there isn't one.
There is no assignment. I can almost recite you your assignment. I don't even have an assignment. You went through my assignment fraud tutorial, correct?
Oh, yeah, and it's just like it. I mean, well,
that's what I was going to say. I can recite it to you. I mean, it's so stupid. You know, you need time machines to do these things. If it was assigned to Deutsche Bank, I'm sure it was assigned to Deutsche Bank as a trustee. A trustee cannot collect on anything because trustees of security pools are specifically prohibited from knowing any of the participants within the pool, because obviously it would be a conflict of interest. So
I caught that on the webinar, and I checked it out, and I have the actual rulings and everything on that. Should I file a quiet title on the house and land, or just the land when I get to that point?
I'd file on everything.
Okay.
Do quiet title on everything, but you got to get yourself up there. Remember, you got to get yourself there, because you got to that judge. You're going to want to know. The judge is going to want to know who didn't respond. Okay, they didn't respond. You tried to serve them. Yep, here's the sheriff. Proof of non-service. Here it is. You don't know who these people are. But first, why not go in and just sue them under the FDCPA and let the cards fall where they may?
Okay. Well, I'm afraid that I'm going to be foreclosed on, not April first Tuesday, but May for sure.
Well, you did a skeleton 13 how long ago?
Oh, I did a skeleton 13 back in December. I could file another one. I could file a 7, I guess.
Well, file exactly. You can file a 13 again, if I'm not mistaken, and because you did a skeleton and withdrew it, or did you let it lapse?
Yeah. Well, I let it lapse because I was told to do that.
Okay, well that's fine too. You can go either way. I like to do a motion to withdraw it and just go through the exercise. But the reality is, at this point, when you file in Fed court, you can come in, like John said earlier, and ask for an injunction. And say, hey, guys, listen, these guys are trying to foreclose on me. Here it is. We're not even to discovery. We're nothing. I'm telling you, here's some more, and you'll probably get it. The federal judges are pretty good guys, I'm telling you. We've had great success with them.
File a QWR, then state injunction? Oh, no? No? Okay.
You've already done your QWR. Who are you going to send your QWR to?
Well, I haven't. I did one back when I was with Jeff's group a while back last year.
Right. And did they respond?
And I filed it. I filed it with Litton, and Litton came back and said the same thing the lady did earlier.
Aaron, exactly. So who did they say they owned? Who did they say owned it at the time?
Well, they never said anything, but when I got the letter from the attorney that there was going to be a sale back in November, that's when they brought up Deutsche Bank. I'd never heard of Deutsche Bank before that.
Gotcha. Yeah, well, what I like about it, this is perfect, the attorney, right? So you just tell this attorney that you just received the notice from, that you just sue him too.
Okay. I got it.
You sue them all, man. I mean, you just sue them all, man. Every one of them. Every name you can find.
Yeah, last question. Tomorrow at 3 o'clock on the webinar that I've got the invitation here, but it says to sign up for it. Do you have to sign up for that or just be a member?
You don't have to sign up to be you're a member. That's for the member webinar.
I'll be talking to you on the non-judicial foreclosure part 3 tomorrow because like I said, I wore out your archive on 1 and 2. So,
okay.
Thank you. I appreciate it.
Thank you, Bob.
The greatest information. Thank you.
Thanks, Bob. All right, man.
Okay, we got Harold.
Here, 14. Let's go another couple questions, and then we'll cut this thing out.
Okay, we got Harold.
Can you hear me?
Yes.
Good evening.
Hi, Harold.
Quick question. I sent you an email, but I can ask it now. I don't do the monthly thing. Is it a way that I can do a one-time payment for the year?
Yeah, I know you can, Harold. As a matter of fact, send my whoever sent you the email,
Jeff.
Send them an email back.
I did.
And they'll give you the information tomorrow. I promise you. Make sure that they get a hold of me, and I'll tell you how to do that.
No, number two. I was asking this question as I was putting the email together, and you had mentioned something about you'll be creating an affiliate program.
Yeah, we're going to start an affiliate program here soon. I don't want to really go into depth about that right now at this moment, Harold, but we are going to offer it obviously to our existing membership first, and then to anybody outside that membership after the fact.
Okay. Now, If Jeff, if you can connect us, because there's something that I would like to discuss to make it perhaps even a bigger thing, to get more people and more exposure for this group.
Sure.
Yeah. Well, listen, guys, let me add to the affiliate deal. I want to make sure, Harold, that everybody knows.
Yeah.
Give me a second, Harold. I don't mean to interrupt. Well, go ahead, Harold.
Okay. I'm setting up a social network that's based on law, education, and also natural health.
Cool, man.
And this group will be a perfect group to be a group within that group to do your thing, because it sounds like you're on the ball. You're in the area mostly that I don't deal with, which is credit cards. Although I used to do them, I never lost one. But I'm dealing more so with the foreclosures, and it sounds like you got some tips and tricks that I can actually use in my my own to save me some time. So keep up the good work and get us in contact.
Yeah, you'll hear from us tomorrow, buddy.
All right.
Appreciate it. Have a great night, man. Okay.
Yeah.
Thank you, Harold. Rose, you're up.
Yes. Hi. Good night. Very good information. I have 4 liens against me. 2 IRS, 1 from the state, and 1 from the Homeowners Association. Are these liens that your program would apply to? Hello?
John, are you there?
Yeah.
Well, I would say
no, not you. I'm talking John.
The collection process, like the FDCPA and all that.
Yeah.
Yeah. With the other liens, they're so different. They're not just a creditor judgment lien. It's IRS, HOA. Those are different, each of them. But generally, it's better just to go after them for the collection practices.
Okay.
Yeah.
Okay.
And the FDCPA does apply to the IRS, by the way. Now, remember something here that I've always told everyone. I'm going to keep this short, Rose. That'll give you a little hint. 99% of the time, when the IRS does a lien or does a garnishment, they never really have the right to do it, as we all know, and I'm not going to go into all the in-depth about not paying taxes, et cetera, but what I'm saying is, generally, it's just a notice of intent to lien, and all of a sudden so there's no judge's signature, there's no judgment assigned, there's no proof up hearings, there's nothing involved.
Right.
So what they've done is they've generated a false security. So what I like to do is go to the comptroller's office here, okay, and the public record, say, excuse me, I need to see a copy of the judgment that was signed by the judge. Okay. They're going to go, what? Well, there's an intent to lien notice here on file. Where's the judgment? Because they bypassed the judgment and they've already garnished me or liened me. Now, where exactly is the signed copy of the judgment? Well, there isn't one. Really? Can you please remove this then? Because I need to stop this. So can you put this in writing that there isn't a signed order by a judge on a judgment here? You see where I'm going with that?
Yeah, I see. I hear what you're saying.
Very, very simple stuff.
Then how do I get my money that they've taken? Because they've
That's a whole different animal.
Me
You're
out.
Sue them. That's a whole different animal, and that's you're going to have to sue them. And John, listen, John knows IRS stuff that he knows more stuff, or probably forgotten more stuff than I know about the IRS. But they took money from me, and I did get it back, and this was back like in '99, 2000. So, you know, it was threatening to sue them and sue the agents personally, and I mean, I went nuts. I'm lucky I didn't get arrested, but the reality is there is ways to do it, but that's where you start, because what's on file that would justify them taking your money? Because that's not a lien, that's not a judgment, there's no order, there's nothing. It's just a notice. Okay, notice doesn't give you the right to jump into my bank account or my wages.
Also, keep in mind the question. Figure out the answer to the question of what are those liens being used for? Are they being used to levy your bank account? You know,
but I don't have a bank account anymore. They took every dime out of it, out of my retirement fund. I had like
$7
bank accounts. Yeah, they cleaned me out. I'm basically living on scraps that anybody who I know can give me.
You don't have any bank account?
I have a bank account, but it has nothing in it. I have my mortgage, my Bank of America, which now I'm learning that they really don't have my mortgage, but they've been offering me mortgage modification packages. My car insurance, I had to put that on my daughter's insurance because I couldn't pay it. I can't pay anything. I've lived for like 3 months without heat. You know, it's crazy.
Yeah.
Wow.
Well, yeah, but your spirit's good.
It has been a learning experience.
Yes, and just be grateful that you have a roof over your head.
They can't levy that anymore.
So,
yeah.
Picture banking so they can't levy it anymore. So that way, those liens can't be used to levy cash in the bank. So the membership area shows you how to do that.
Oh, okay, great.
Yeah, it takes
and remember, you
about 7
can
days.
pull your credit report, okay, and start making money right off the credit report.
You probably have lots of
Please, I know you say you don't have a lot of money. You don't. If anybody on this call actually knows Rose, help her out, get her started.
Yeah.
I mean, that's something we encourage. I was going to say it to Harold. Listen, if you're a member and you know somebody who's in dire straits and needs the help them out. You've got the dang resources. You've got the tools. And you'll be paid tenfold. That's just the way karma works. So don't just think of yourself. Help your neighbor. Help everybody else. There's issues here, okay? Especially in states like Florida where we got a homeless bus route to pick up these kids that are living out of hotels and out of the cars. It's a sad, sad state. 23% of everybody in Osceola, Orange, and Seminole County, these are kids are homeless. 23% of kids are homeless. That's pathetic. It brings tears to your eyes. So, you know, help your neighbor. Reach out and help. We encourage that a lot.
Thank you.
Thank you, Rose.
Okay, thank you.
I just looked.
Okay, we've got an anonymous caller here for whom I have no name or number. You should have heard it being unmuted. You don't.
I'm sorry. Can you hear me?
Yes.
Can you hear me?
Yes.
Okay. I'm calling from my Skype. I'm calling from my Skype call. I apologize for that. You've actually practically answered every question for me. If I can get the gentleman who mentioned something about something that took place in the federal court in January with some judges or something. He mentioned that something new, a wave of something that took place in January with judges.
Oh, no, it's not with judges. That was.
Are you referring to the Supreme Court order?
Yes.
Jeff, we got an echo, Jeff.
Yeah. How were you contacted to be on the call?
Through email from Jeff.
Okay, then hit a reply. Take that message, hit reply, and tell him you want the Supreme Court decision of January 2010 as it pertains to FTCPA, and he'll send you a copy.
Thank you so much. I appreciate that. Thank you, guys.
You're welcome.
All right, guys.
Thank you.
Jeff, I want to wrap this up. How many calls do we have left, sir?
You mean how many questions? We got 4.
Yes, sir. Okay, let's tap out. Larry, you guys all right with that, John?
Yeah, that's fine. And keep in mind, people, if you don't get your question answered this week, then just call back next week and ask it.
Yeah. Okay.
There you
go. Go join him.
Ron, you're up.
Yes, sir.
Better yet, join and put stuff on the forum or listen to the webinars.
Right.
Yes, this is Ron in Colorado.
Uh-huh. Yeah,
Hi, my question is, I've got several people calling me on the same debt, It's a credit card debt. One is taking me to.
I'm sorry, Ron. I'm sorry, I'm laughing, but I've already been through that.
Oh, you've got a 52 pickup. That's great.
Yeah, I can tell you why Jesse is laughing, because we're both counting the money that you're making in our heads as you speak.
Yeah, God Almighty! Several people calling you over the same debt. That's a good one.
Yeah, I have about 11,000 on my card, and through U.S. Bank, a lot of craziness happened, and tried to work it out with them, but they ended up, and I've got it on my credit report that they sold the debt, and that they got a write-off on it. It says right on my credit report. All these people are on my credit report. A lot of them are going after me, and they're calling, and one is taking me to a pretrial here in about 10 days. I've done everything to have them understand that they don't have any standing, and he asked me, he says, is your wife Patricia as ignorant as you are? And I said, well, I don't understand all that, but you don't have any standing in this.
Larry, address that.
Do you understand that that is a scurrilous remark?
Yeah. I mean, I'm thinking right off the bat. Yeah, right off the bat, both you and your wife should file individual lawsuits in both federal and state court against the attorney, and you know, it depends on who's going after you, but you know, 4 lawsuits all at the same time.
Ron, they can't do that. That's a scurrilous remark.
Well, I didn't have it taped, but and then they set me up to go into a pretrial, so I went to the pretrial. As soon as I sat down with the fellow, he says, "Ron, so are you ready to take care of this debt?" And I said, "Well, who are you?" And he says, "I'm the debt collector." No, he said I'm here to make arrangements to collect this debt with you. And I said, "Well, are you the debt collector?" He said, "Yes, I am." I said, "Well, you don't have any standing in this." And it's like I poked him in the behind with a pin. He jumped up. He says he jumped up and said, "We'll see you in court." And I walked through the court when he was making the date for the court, which is the date coming up. And I said, "Well, you don't have any standing. I don't understand why I'm even talking to you."
Did you say that you physically accosted this guy?
Well, no, but it's like I poked him in the behind with a pin. He jumped up, so he just about knocked the table over. When I told him he doesn't have, I said, "You don't have any standing in this. You're not the one. You're not my. I didn't have any arrangements with you." And he got right mad. He got really physically just about flipped the table over.
Ron, stop! You don't have an arrangement with anybody. Not him. Anybody. Okay. Remember that. I don't remember. I don't recall.
This was in a, like, he took me in a room where it was just him and me.
What is your question, Ron?
My question is, how do all these people that are calling me on the same debt, to sue them, is that what I have to do, is sue every one of them?
Yes.
You got it.
And I'm not as brilliant as you guys by any means, you've been doing this for a long time. How do I know what to go after them for? I mean, just knowing that they don't have the right, because it's all about the U.S. debt, or U.S. bank. They're not the creditor, I know that.
No, wait a minute, Ron. This is not about the debt. This is about their misbehavior.
Okay.
Quit bringing up the creditor. You don't have a creditor. You are the creditor. Stop that.
Okay. Well, I never talked to him like that. All I said to him is that you don't have any standing. That's why am I talking to you? And he jumped up.
Once the account is sold, nobody has any standing because they can't bring any witnesses with first-hand knowledge that could testify to any facts, any records, any contracts, any agreements, anything. Understand that.
Okay.
So everybody's trying to get to you now. You just got to turn around and file one federal lawsuit against all 4 of those people or 5 of those people. And
yeah, there's quite a few of them. I said there could have been 6 or 7 of them. There's all kinds of people calling me on the same debt.
That's fine. Yeah. That's just more money for you.
Okay.
Quit your complaining.
Well, I'm not complaining. I'm just trying to understand. So I'll sue them all, put a suit against them all, and to learn all this, I've gone through your site quite a bit. A good friend of mine, Ray, in George, is just he knows 1,000,000% more than I do. He's helping me. But
Ray's a great guy. A good friend of mine too.
Yeah, he's just a great guy. But he's helping me. We're going to compile what we need to get against these. It's just he said the same thing, Ron. He said, just quit worrying about it. It's crazy what they're doing.
Right.
Worrying ain't going to get you nowhere. Get some paperwork pulled up. You know you got all the resources right there on the member site. Get in there, file up your templates, and get it knocked out.
Yeah, I appreciate it. I just wanted to, and Ray said that, he said that's what we got to do. We got to sue these people. But my question tonight was, do I sue them all? And I guess it is.
Absolutely, and including that attorney. And you said you have 10 days, right?
Yeah, I've got it's coming up here first part of this next month. I got 10 days. We'll get a suit against them.
You should be able to have that. You should be able to have your complaint struck and filed by Friday.
Okay, I'll work on it, and I do appreciate it. Love your site.
God bless you, man.
Thank you so much.
Okay, we got Steve, who's up.
How you doing?
Pretty good.
Just got a quick question for you because I know you got to go. I received my credit reports, and my second mortgage company has written off the debt as per the credit report. And I know you touched on this earlier, but they're still sending me a letter asking to settle for $68,000. Can they do this?
Absolutely. You can write it off for this tax year, but that doesn't mean that I can't go after you for the remaining balance and then bring whatever I collect in as a profit for the following year. That's the whole misconception that people have. Does that make sense?
Makes sense. Thank you.
All righty, bye.
Thank you. Kim, you're up.
Yes, hi, this is Kim, and I had a Capital One letter, and I got it, and my purse was stolen, and then it got closed out. I did have that credit protection in case you can't pay the bill and everything. Well, what happened, I made a payment arrangements for them. They never took them out, and it caused everything to go in default, and then I kept getting all the late fees and the over-limit fees and everything. And then I went to court, I believe, in '06, and I did this thing that I found on the Internet with this guy that won a case in Cleveland for Capital One against a mortgage and for credit cards. And they put some kind of judgment on me. And so now, this is March 24th, 2011, I got a notice of court proceeding to collect the debt from a law firm, and it's just saying the undersigned Capital One Bank, and it says I owe $59.22 and change. And it says about a judgment which was obtained against you in a certain court on March 26th, 07. And they say if you do one of these things within 15 days of the date of this notice of its service by the court, we will go to court unless we're otherwise precluded by law from doing so. They ask you what an employer be ordered to pay.
Wait, they said that you had 15 days to dispute the debt?
No, they didn't say I had 15 days. They said I got a judgment, and I told them to, I wrote this one letter that a lawyer sent me, and it said, please prove the debt, the original copy, the counting practices, the balances, any cosigner, da-da-da-da. They never did anything. So then they took me to court, and I sort of represented myself, but I know someone that did something like this, so I thought if it worked for them, they've been living in a foreclosed house for 8 years, so I figured if it worked for them, it might work for me. But the magistrate made me a judgment, and they said I don't know what kind of judgment it was because I'd have to look through all the papers. But now this law firm, and they're like the most rotten ones where all the prepaid legal lawyers go to, they would walk down the aisles and tell them, be more mean, be more mean. So they're trying to say I have a choice to do one of three things or else they're going to go to court for me and try to get my garnishment. But see, I got a judgment.
Look, Kim, you need to stay with the question and stay clear. You're all over the place.
Hey, can I let's just make this simple because Capital One is one of my favorite people to sue. I've got a $10,000 judgment against them, and I've sued them again, and I'm expecting another $10,000. You need to sue Capital One. You need to sue the attorney. You need to sue the law firm. You need to sue everybody. In fact, you should sue the whoever gave you that credit card protection account too for breach of contract, if nothing else. But first thing you need to do is sue everybody else in federal court.
People, I guess people on this call and our members, I guess our members are getting it, but the reality is you don't understand the power of just suing because you're going to sue Capital One. Capital One's going to say, wait a minute. Why are you suing us? We sold that debt to that attorney. But you would never find that out if you didn't sue them. People don't understand the power of a lawsuit in federal court. They have no idea. It makes people shit their pants, excuse my French. Because they know they're not going to get that song and dance to that judge. It's not going to happen. It's just not going to happen.
Can you ever sue the judge? So you
need to understand that. You find Capital One, you sue them, you sue those attorneys, you sue, like Larry said, everybody. And all of a sudden, people are going to come out of the woodwork. Hey, wait a minute. What are you suing us for? We sold this debt back in 2007. Oh, you did? Then why are you suing me under Capital One's name? Attorney. You see? You would never know these kind of things unless you sue. These are things that we've experienced, that we've seen, that we know happen. But why? Because we sue and then ask questions later. We don't ask all the questions you guys ask and then try to sue. We just sue now. And that's it. That FDCPA is freaking like a cannon, man.
Okay, but and then could I just say, they say to avoid garnishment by doing one of these three things within the 15-day period. Pay us the amount due, which they never proved the debt the whole time I did it. Complete the attached form payment to avoid garnishment and return it to us with the payment, if any, shown due, or apply to your local municipal or county court if you're not a resident of Ohio, or to the municipal or county court in whose jurisdiction your place of employment is located for appointment of a trustee to receive the part of your earnings that do not exempt from garnishment. Notifies us that you have applied for the appointment of a trustee. You will be required to list your creditors, the amount of their claims.
Kim, what are you asking?
So I don't have to do any of these things. I just have to go after them and sue them.
You're saying in federal court.
Okay, because you know what?
Listen, just send them a simple note. Are you a member or not a member?
Well, I just found out about it today from Carol, who called before and asked if you're on Tuesdays, and I'm dog sitting and her computer doesn't work, so I'm going home tonight to sign up. So I'm going to do
sign up. Go in there. Listen to me. You go ranting around a lot. Go home. Sign up. Get in there and get in a notice of dispute. You see how simple our notice of dispute is. There's nothing fancy about it. There's nothing big about it. You send it out to the attorney, and you send it out to Capital One. Because anything they do within the next 30 days or until that debt is validated, anything they do is a violation of the FDCPA again. Now, what they're going to do is send you a copy of the judgment and say, here, it's validated. But in the meanwhile, you've bought yourself time to hurry up and get them sued.
Right, and check your credit report, and the instructions for it are all on the website. Just go through it step by step, and you're setting them up big time. They're going to violate all over the place if you let them.
Okay, and then another thing, could I go back and get the attorney who tried to do it the first time from Capital One from 06 or 07, what year it was?
No, the statute of limitations way beyond.
Okay, I could only do this one now, right?
Right, that's what I would do, yes. Just to be safe.
Okay, and send it registered mail so that, like, at least you get a signature on it that they received it, because if you just send it, they might not.
You don't need to do that. No, save the $5 or $6. You send it certified mail without the return receipt. They accept it. It's scanned. You go down to the USPS site. You print that out. There's your proof. You're done.
Okay. And
Save your money.
And so, like, that's what I have to do. Do I need a lawyer to do this or no?
Listen, I can't give you legal advice. That's up to you. If you want complete legal advice, go to a lawyer. Then ask that lawyer, will he sue another lawyer? And then that's going to answer your own question.
Yeah. So I have to ask a notice of dispute, which is you're challenging them to prove the debt, correct?
That's just notice of dispute. Here, validate and verify the debt. There's two different requests there. It's very simple. It's 2 paragraphs long. It's done. It's simple stuff. Nothing of this fancy 25-page request that they're not going to answer and they're not obligated to answer. So the reality is, the simpler it is, keep it simple, stupid. That's all.
Yep.
Mm-hmm.
So.
Okay, so...
All right, 9:40.
Thank you so much. I appreciate it. I'm going to sign up when I get home in a little while.
All right. God bless you. You have a good night. Jeff, with that, can we wrap it up, or is there one last one?
Yes, we can. We did have another question, but they dropped out, so we're free and clear.
All righty, guys. God bless you. Thanks for joining the call. Like I said, go out and join. Anything you need is right there in your email link. And we'll see you on the forums for the members. If not, we'll see you next Tuesday, guys, and have a great week. And that's about it for me.
And take care, everybody. Thanks for listening.
Good night, everyone.
Good night, guys.